Good afternoon to the learners as well as academic counselor Mr. Ramanamurthy. I think today we are going for the third class. I hope you are all understanding the subject.
Fourth class, sir.
Today is the fourth class. Uh,
Yes, sir.
and we are regularly uploading the recorded sessions in our RC Vishakhapatnam YouTube channel. Even later days also, you can again listen before your examinations if you want to do the revision and if you want to see the some of the information. For that purpose, we are recording every session and we are uploading the same in our RC Vishakhapatnam website. You please subscribe and tell to your friends also. Even yesterday lesson also we have uploaded, and every day we are uploading it. Please make use of the facility. Thank you. I request Mr. Ramanamurthy, please continue. Thank you, sir.
Yes, sir. Good afternoon,
Yeah,
friends.
please go ahead.
Today, yes, sir. Today we have to discuss the organizations, international organizations with regarding to the patent protection, that is World Trade Organization, TRIPS, and the enforcement of TRIPS agreement. So yesterday we are done with the establishment of Paris Convention, Patent Cooperation Treaty, Patent Law Treaty, World Intellectual Property Organization. So today we have to deal with World Trade Organization and TRIPS. So what is this World Trade Organization and TRIPS? What is the genesis of its these two organizations basically? So at the time of Second World War, the countries are facing so many economic problems, economic and societal problems. Post Second World War, so there is a proposal came from the then two big countries known as Britain and USA. So Winston Churchill from Britain and Roosevelt from USA, they discussed to establish a universal organization which should maintain and implement the international peace and security, that is known as United Nations organizations. So this was the predecessor of this was the postdecessor of League of Nations also, which was established in 1919 after the end of the First World War. So during the discussions of establishment of the United Nations organization only, there is a proposal to establish three more institutions. Those are IMF, International Monetary Fund, IBRD, International Bank for Reconstruction and Development. It is famously known as World Bank, and ITO, International Trade Organization. So if you also know that both IMF and IBRD, World Bank, are known as Bretton Woods twins, because these were established based on the Bretton Woods Conference in 1944. But not established along with these IMF and IBRD, because some of the members, some of the participants in that time, they are not in favor of establishment of this international trade organization. But so many ongoing negotiations, the world communities thinks that there must be a need for one particular agreement which will deal with the trade and tariff. So to deal with the trade and tariffs in the global level, a provisional agreement that is known as GATT, General Agreement on Trade and Tariff, was established in 1948. So this GATT, whenever they were meeting in the GATT, then it is called negotiation. So the eighth round of negotiations of this GATT held in Uruguay. This is known as Uruguay round of negotiations in 1986. So till 1986, from 1948 to 1986, the GATT was deal with the only trade and tariff of goods and services only. But first time in 1986, in the Uruguay round of negotiations, they included a new area known as IPR and investments and services to bring down the tariffs on such goods. Why this was happened? Because due to the emerging technology and technological innovations in the decade of 1980s, so the developed countries and international agencies projected these intellectual property protection as the major factor to growth in the world trade in the GATT's Uruguay round of negotiations. So these GATT's Uruguay round of negotiations of 1986, 1986, it came later through the series of negotiations. Finally, in year 1994, they signed a final act at Marrakesh, Morocco. It leads to the establishment of permanent institution known as World Trade Organization. So this World Trade Organization is a permanent organization. So World Trade Organization, it could be regarded as the primary international organization dealing with the global rules of trade between the nations. All the members of World Trade Organizations are subjected to the periodic review of their trade policies. Periodic review means for every 2 years review or every 3 years review, like that. So their trade policies to ensure transparency and adherence to according to the World Trade Organization agreement. Currently, there are 164 countries were members of this World Trade Organization, which accounted 98% of the global trade in the world. So what are the features of World Trade Organization? So basically, the World Trade Organization is concerned with the trade between the nations and strives to develop universally agreed global trade rules. At the same time, it stands for liberalization of the trade and services. It provides a basic legal framework for its member countries to conduct the international trade and commerce. At the same time, the World Trade Organization has also the effective dispute resolution system to settle the disputes very speedy. So what are the objectives of World Trade Organization? Yeah, the objectives of World Trade Organizations are to enable free flow of global trade without undesirable side effects. Second one is to allow governments to meet social and environmental objectives. And third is to establish a transparent rule-based system for global trade where everyone is to abide by these agreed rules. These are the objectives. So what is the difference between GATT and World Trade Organization? As I said that GATT was a provisional agreement. It is not a final agreement. So GATT was a provisional agreement concluded in 1948 and continued till 1995. Whereas World Trade Organization is a permanent institution established in 1995. And the second difference is GATT deals with the trade in goods only. GATT deals with trade in goods only, but World Trade Organization covers trade in goods, trade in services, trade in intellectual property and investments also. GATT was an agreement rather than organization. So it is agreement. It was formed because of many series of negotiations. At the same time, it lacked a formal institutional framework. But whereas World Trade Organization is having a formal international organization with a strong institutional framework. Further, we should discuss what is the structure of this World Trade Organization. So it is basically a legalized institutional framework, but GATT was not having a institutional framework. In the case of dispute resolution, GATT being an agreement, it requires a consensus of members, whereas World Trade Organization has a structural dispute settlement mechanism. It allows for binding resolutions to trade disputes. So with regarding to membership, GATT has 123 members, but World Trade Organization has 164 member countries. So what are the trading principles under the World Trade Organization? So the first principle is trade without discrimination. Trade without discrimination. So in that very beginning is most favored nation treatment. The most favored nation treatment is nothing but the member country can give some special status to the other countries to implement the trade between them, trade or services or to protect intellectual property between those countries. They can trade the most favored, they can give the most favored nation treatment. So basically, the most favored nation treatment ensures non-discriminated this most favored nation treatment. A member country must provide the same favorable trade terms to all World Trade Organization members. That gives most favored nations treatment to the other goods. Then, according to this most favored nation treatment, India has to give same treatment if that same good was exported to the Bhutan or Nepal. So that is the most favored nation treatment. You should not discriminate between Sri Lanka and trade with Sri Lanka and trade with Bhutan or trade with Nepal. It helps to create a stable and predictable trading environment which benefit all World Trade Organization members by fostering open and competitive markets. Basically, this most favored nation treatment clause, it was included through the bilateral treaties concluded during the 18th and 19th centuries, particularly based on the friendship, commerce, and navigation treaties. This most favored nation treatment applies to trade in goods, trade in services, and trade in intellectual property rights. But there are some exceptions to this most favored nation treatment. According to the most favored nation treatment, one member country should not discriminate other member country to trade. But the exception to this principle is that means you can discriminate. How? For example, if a group of countries can enter into a free trade agreement in respect of goods that they are traded within the group only. For example, SARC is a regional cooperation. The SARC, the acronym It stands for South Asian Association for Regional Cooperation. So there was initially 7 member countries. Later, Afghanistan was added. Now it is 8 member countries. So these 8 member countries, they make an agreement by saying this is a free trade agreement between the SAARC nation countries. Then if India, under this free trade agreement, under the SAARC, if they are trading with Afghanistan for some leverages were given, then if that India for that same product, if it makes an agreement with to export to some non-SAARC member country, then that leverage which India give to the SAARC member country should not give. So that is the exception to the most favored nation principle treatment. Second one is, if a country wants to give a special access to its markets to developing countries. So for a developed country, to give its market access to the developing countries, can give that most favored nation treatment. So can discriminate with regarding to trade. Then they can cancel the importation fees. Like next, a country can raise barriers against goods from special countries on consideration of unfair trade practices. For example, now there is a war was happening between Israel and war was happening between Russia and Ukraine. So all the vehemently said that no country should trade with Russia until unless the Russia stop their war in Ukraine. But what India does, India, it was continued its trade. So in this case, you cannot call it as a trade without discrimination. So these are the exceptions. These exceptions are permitted only under the strict condition only. The second principle is national treatment. So national treatment, it means already we observed the national treatment principle in the very beginning class only. So that means the foreigners and locals should not discriminate. So if in a country was a member of World Trade Organization, it should treat its own citizens and the foreigners as same. So it ensures foreign goods, services, and intellectual property rights, they are treated no less favorable than domestic ones once they have entered in a member country. The foreign goods should not face additional taxes, regulations, or restrictions that do not apply to local goods or services. So the national treatment principle apply after a product or service has entered into the market, not before that. For example, if a country imposes a 10% sales tax on domestic cars, it must apply same 10% tax on the imported cars. You should not give more. You should not give biased decisions with regarding to that. But this also comes under certain exceptions. It doesn't require countries to extend equal treatment in government procurement, allowing countries to favor domestic suppliers in this area. That means if you want to import something, but that resources are already available in India, available in that particular country. If that particular country, the policymakers thinks that why don't we increase our domestic supplies? So by making that country, so they are making some leverages to them. So if any such type of discrimination is there, even though that will be accepted in this national treatment, and certain measures may be exempt for reason of health, safety, or environmental protection, as long as they are not applied in a discriminatory way to favor domestic goods or over foreign goods. So these are the two exceptions with regarding to national treatment. Third one is free trade. So imposing custom duties, selectively restricting quotas of import of various items. So banning of imports altogether comes under this obvious barriers. So this World Trade Organization agreement encourages progressive liberalization. Next principle is predictability. So the economic development of a country requires foreign capital, technologies, and expertise. So foreign investments are drawn if there is a promise of stability and the policy environment is predictable in that particular country. So the member countries, along with WTO organization, they have started the multilateral trading system, so which creates stability and predictability in the business environment to develop in their economy of that particular member country. Next principle is transparency. So basically, the world members must publish their trade regulations, tariffs, and practices and notify the World Trade Organization of any changes. So there is a one mechanism called trade policy review mechanism in the World Trade Organization, which keeps national trade policies under their regular surveillance. So this will help to strengthen the transparency between the nations. Fair competition. So World Trade Organization encourages fair competition in free trade through the degree of is circumscribed by reality. So the circumstances where trading practice of a company are proven to be unfair, as in the case of dumping and subsidies, the World Trade Organization rule permits a rising of custom duty and other forms of protection because it will hamper the fair competition. The next principle is development and reforms. To developing countries, the World Trade Organization agreements provide for a special assistance and trade concessions to them, to the developing countries and countries in transition to market economy have been given time to comply with the requirements of World Trade Organization agreements. So the developed countries have opened their markets to exports from least developed countries, allowing duty-free, quota-free imports like that. So these are the principles given under the World Trade Organization. So what are the agreements made by the World Trade Organization till now? So the World Trade Organization is a system based on the rules. What are these rules? These rules are the agreements which the member countries of the World Trade Organization have arrived after a detailed negotiations. So these World Trade Organization agreements are classified, covers three broad areas. So that is with regarding to goods, with regarding to services, and with regarding to intellectual property rights. So with regarding to goods, it is known as the GATT, General Agreement on Tariff and Trade. It exclusively deals with goods. Next, the General Agreement on Trade in Services. It exclusively deals with services. And TRIPS, trade-related aspects of intellectual property rights. The agreement on this TRIPS deals with the intellectual property issues. So all the members of World Trade Organization have to abide these agreements. Under the GATT, the additional agreements also there. For example, agriculture, textile and clothing, health products, investments, chip management, pre-shipment industries, anti-dumping measures. So these are some of the extra additional agreements which was done by this GATT. So the GATT also deals with movement of natural person, air transportation, financial services, shipping, telecommunication. But the TRIPS has no additional agreement. So the general agreement on trade and tariff and trade, it has additional agreements. At the same time, general agreement on trade and services also have additional agreements, but the TRIPS, trade related aspects of intellectual property rights, has no additional agreements. So what is this TRIPS agreement? So TRIPS agreement, it brings the protection and enforcement of intellectual property rights under common international rules. So based so many from the 1883, so many negotiations were done, so many conventions are happened, so many conferences were happened. So this TRIPS agreement try to understand the common international rules, how to implement protection and enforcement of IPRCs provided by these common international rules. So it laid down the minimum levels of protection of intellectual property, irrespective of its country of origin. So the TRIPS agreement recognizes 7 types of intellectual properties. That is copyright and related rights, trademarks including service marks, geographical indications, industrial designs, patents, layout designs of integrated circuits, and undisclosed information including the trade secrets. These are the 7 intellectual property rights which were recognized by the TRIPS agreement. So what is the issues to deal with TRIPS agreement? So basically the TRIPS agreement deals with the 5 broad issues. So the basic principles of trading system and other intellectual property systems, those are national treatment, most favored nation treatment, technical innovation and transfer of technology. And the second one is adequate protection to intellectual property rights. So that is, agreements provides common ground rule to protect intellectual property. Registration is required in the case of patent, industrial design, integrated circuit design, geographical indication, trademarks. And trade secrets. And third issue is enforcement of the infringement of intellectual property rights attracts through the penalties under the domestic laws. At the same time, it has a mechanism for settlement of disputes between members of the World Trade Organization. It has a special transitional agreements also. So the World Trade Organization, which came into force on 1st January 1995. So it makes a final draft on Marrakesh, Morocco. So the developed countries had to bring their domestic laws in conformity with this TRIPS agreement within 1 year. So from the date of 1st January 1995, the developed countries had to bring their domestic laws in conformity with the TRIPS agreement within the 1 year. The developing countries and the economics making a transition to a market economy had 5 years to do. But the least developed countries has 11 years to do. So within these 11 years, the least developed country will have to bring their domestic laws in conformity with this TRIPS agreement. But the TRIPS agreement, the provisions by the developing countries, they face it difficult while implementing. So to resolve these difficulties, Doha Development Agenda DDA was launched by the World Trade Organization in the year 2001 in Doha. So the Doha Development Agenda was focused on promoting development and addressing issues facing developing countries in global trade. So what are the key objectives of Doha Development Agenda? So the key objectives were it lowering the trade barriers in areas such as agriculture, services, and industrial goods. In agriculture, reducing subsidies and improving market access for farmers. And third objective is prioritizing in the field of access to markets and fairer trade conditions. And the fourth objective was with regard to intellectual property rights, balancing protection with access to medicines, particularly in public health crises such as like HIV and COVID, AIDS. And the last objective was integrating environmental sustainability into trade policies. But this Doha Development Agenda was yet to be reached a comprehensive conclusion because the subsidies given in agriculture sector and tariff reduction in developing countries, the developed countries were not accepting these leverages to the developing countries. So because of that, the DDA, Doha Development Agenda, yet to reach a comprehensive conclusion. So what is the structure of World Trade Organization? You can broadly divide the structure into 4 levels. So in the first level, the World Trade Organization, all the major decisions are taken through the consensus by the members together usually in the first level. In the second level, to look the day-to-day effects or activities, 3 bodies were established. Those are the General Council, the Dispute Settlement Body, and the Trade Policy Review Body. Ministerial Conference is the policy-making body of the World Trade Organization. So Ministerial Conference is the policy-making body of World Trade Organization. So the General Council, it is regarded as the Executive Council of the World Trade Organization. So the General Council also sits as a dispute settlement body to implement the reports of the panel and appellate body, and also sits as a trade policy review body to review the trade policies of member countries. See, this is at the second level. The third level, there are some councils were established with regarding to goods, services, and intellectual property rights. Those are Council for Trade in Goods, Council for Trade in Services, and the Council for Trade Related Intellectual Property Rights. All of World Trade Organizations are the members of all these councils. Finally, at the fourth level, all the subsidiary bodies of the higher level councils are established. That is, with regarding to committees deals with the market access, agriculture, and anti-dumping practices like that. Though the decisions are made through consensus, there is a provision for voting also. The voting is based on the one country, one vote to decide on an issue. If a consensus is not possible, the decisions are taken according to the some rules which are for adopting an interpretation of any of the multilateral trade agreements. A majority of 3/4 of World Trade Organization members is needed. For adopting interpretation of any of the mutual multilateral trade agreement. The ministerial conference, through a majority of 3/4, can waive an obligation imposed on a member under a multilateral agreement. The third one is amendment to the provisions of multilateral agreement can be adopted if approved by all members or by a two-third majority, depending on the nature of provisions. But the amendment is applicable only to those members which accept them. The last one is a decision to admit a new member requires a two-third majority in the ministerial conference or in the general council in between the conferences. So what is World Trade Organization Secretariat? The World Trade Organization Secretariat is in Geneva, Switzerland. It is headed by Director General, who is supported with 3 other deputy directors. So the Secretariat has 18 divisions. It has also a training and a technical cooperation institution, a trade and information center, and library. Next one is dispute settlement mechanism and procedure of the World Trade Organization. The dispute settlement mechanism of World Trade Organization having a unique feature. So the guiding mantra behind this dispute settlement mechanism is equitable, fast, effective, and mutually acceptable solutions. So the aim of the exercise is to settle disputes with a view to adjust trade measures between member countries. So the apex body for the settlement of dispute is dispute settlement body. We are already mentioned above. It consists of all the members of World Trade Organization. In fact, the General Council will sit as the dispute settlement body in a dispute settling role. What is the procedure for dispute resolution? When a dispute is received, the countries in conflict are first encouraged to talk to each other, consult each other, and resolve their difficulties themselves, taking help of the mediators if necessary. If there is no resolution is reached within about 2 months, the dispute settlement board body establishes a panel of experts to consider the case. So in this panel, at least 3 to 5 members are there from different countries. They will also choose in consultation with contending parties. So this panel acts as a tribunal. This panel acts as a tribunal. This panel not act as a court under Civil Procedure Code. So the difference between the CRP, Civil Procedure Code, and tribunal is nothing but, in the case of court established under Civil Procedure Code, have to follow the existing code, but the tribunal is need not to follow the Civil Procedure Code or any procedure, such procedure type of code, but even though if it follows, it must follow the just, fair, and equitable. At the same time, the tribunals must follow the principles of natural justice. Yesterday, we are discussing the principles of natural justice, saying that there are some principles of natural justice. The tribunals must follow the principles of natural justice, but courts not. So this appointment of panel, it should be completed within 45 days. Then the panel closely interacts with the parties at each stage. It shows the first draft to the parties so far as the facts and the arguments part of this case are concerned, and seeks their comments within 2 weeks. So the panel then submits an interim report, its findings and conclusions, to the parties, giving them 1 week time to ask preview. So the review is completed within the 2 weeks, and a final report is submitted by two sides within the 6 months. The dispute settlement body considers the report, and if there is no consensus to reject it, the report becomes the dispute settlement body's ruling. So the appeal has to be generally disposed of within 60 days, and in any case, not more than 90 days. So what are the new issues with relates to World Trade Organization? As we know, the rapid development of the infrastructure and the rapid development of the technology innovations, which leads to the further strengthening of World Trade Organization. So the new issues, one is a reform of the dispute settlement mechanism, because the World Trade Organization faced significant challenges, particularly due to the US blocking the appointment of new judges to the appellate body. The second challenge is, or second item which it should be go through is e-commerce and digital trade. As digital trade grows rapidly, the World Trade Organization is facing pressure to update its rules to address e-commerce and the digital economy. The third one is climate change and environmental sustainability. The increasing pressure to address the intersection of the trade and environmental issues has led to the discussion on how to align trade rules with the global efforts to combat climate change. And next one is developing countries and special and differential treatment. There is growing debate over the role of developing countries within the World Trade Organization. Some developed countries like the US argue that certain large emerging economies should not continue to receive the same special and differential treatment as smaller, less developed countries. So, reforming the criteria for special and differential treatment is a contentious issue. The fifth one is trade and gender. So the relationship between trade policies and gender equality is gaining attention. So the World Trade Organization is exploring ways to integrate gender consideration into trade agreements, which aims to promote the economic development and it also encourages trade policies, gender specific and opportunities. The next point is inclusive and sustainable growth. So the World Trade Organization is facing pressure to ensure that trade contributes to more inclusive and more sustainable growth, addressing issues like income inequality and ensuring that the benefits of globalization are more broadly shared. Some argue for rethinking trade liberalization policies to better consider social and labor rights. So what is the TRIPS agreement? Till now we are dealing with the World Trade Organization and its objectives, key provisions, and how many members, what is the difference between World Trade Organization and GATT. Now we have to discuss with the TRIPS agreement. So the TRIPS agreement is also known as trade-related aspects of intellectual property rights. Is one of the most comprehensive international treaties. It governs the intellectual property rights. And it is a cornerstone of the World Trade Organization of the framework. It was adopted in the Uruguay of General Agreement on Trade and Tariff Negotiations on 1994. The TRIPS and the World Trade Organization was sidelinely they came into force, they established, and both are came into force on January 1st, 1995. So, what are the objectives of TRIPS agreement? So, the objectives of TRIPS agreement are first one, harmonize the intellectual property laws globally. So, it established a unified system of IP protection, which allows all the World Trade Organization member states by setting minimum standards. The second one is promote technological innovation. So the TRIPS agreement encourages innovation and transfer of technology through the promotion of intellectual property rights. And the third one is balance intellectual property rights, protection, and public policy. So to ensure this, the enforcement of intellectual property rights, it contributes to technological and economical development while balancing the right holders' interests with the public welfare, such as access to medicine. So these are the three observations of the TRIPS agreement. What are the key provisions of the TRIPS agreement. First, it covers all the intellectual property rights. With regarding to copyright and related rights, it mentions the protects the literary, artistic, and scientific works, as well as the rights of performers, producers, sound recorders, broadcasting organizations. So these all comes under Copyright Act. It governs TRIPS agreement. Next one is trademark. The trademark protects distinctive sign that identify goods or services, ensuring that the companies can distinguish their disputes. Geographical indication with respect to geographical indication, it protects the names that identify a product as originating from a specific region, which leads to the product of the quality or reputation. For example, champagne from the district of Champagne in France. Industrial design. The industrial design protects the visual design of object that are not purely utilitarian. In the patents, the grants exclusive rights to inventor for their invention, including the process or product patent, for at least 20 years. The trade secrets. It protects undisclosed information such as business participates on property knowledge. The last one is layout design and integrated circuits. It protects the design of semiconductor integrated circuits. So what are the minimum standards required in the case of TRIPS agreement? So the TRIPS agreement has sets a minimum standards for the protection and enforcement of the each type of intellectual property. This includes the scope of the protection of duration of protection, and as well as conditions under which intellectual property right can be enforced. The enforcement. So that we are seeing that the enforcement agencies, this would include the civil administration, civil procedure, administrative procedure, criminal procedure. So to control the piracy and counterfeiting. So this TRIPS agreement mandates the member countries must provide effective mechanism for enforcing intellectual property rights. So this TRIPS agreement also emphasizes the border measures to prevent the implication of goods that infringes intellectual property rights. The flexibility for developing countries. Basically, the TRIPS agreement, it give developing and last developed countries flexibility in implementing the agreement. Some of these flexibilities are like transport periods, compulsory licensing, parallel importation, and technological importation. So, with regarding to the flexibilities for developing countries, the least developing countries and the developing countries, the TRIPS agreement provides some sort of support in the case of technology transfer or compulsory licensing. And the dispute settlement mechanism. So the TRIPS agreement, being a subject of the World Trade Organization's dispute settlement mechanism, the interpretation or application of the TRIPS provisions can be resolved through the World Trade Organization's established process. So, what are the key debates and controversies which tied with the TRIPS agreement? Number one is access to medicine. One of the most contentious aspects of the TRIPS agreement is its impact on public health, particularly in developing countries. Because due to the high cost of patented medicines that has led to the criticism, it creates a barrier to access the life-saving drugs. So because of this, 2001, there is a DDA declaration, Doha Declaration Agenda on public health, which clarified that TRIPS should not prevent countries from taking measures to protect the public health and allowed greater flexibility for compulsory licensing. The second key debate issue is patenting of life forms. So the agreement required that patents be available for any inventions, but it leaves some room for exceptions, such as the exclusion of plant and animals other than microorganisms. So this leads to the patenting of genetic material and biotechnology. Next, the third concern is with regarding to geographical indication. So these are ongoing debates over the scope and enforcement of the geographical indications, with some countries seeking stronger protection for the products with specific geographical origins, while others argue for more flexible terms. So this is the base, the fight in between the TRIPS agreement only, the members of the TRIPS. And last concern, it deals with traditional knowledge. What's the impact of TRIPS on traditional knowledge? The TRIPS does not specifically protect traditional knowledge or folklore. This leads to the concern that indigenous knowledge, especially in developing countries, is not sufficiently protected from the exploitation. So, what are the key developments initiated to take TRIPS agreement universally accepted and more powerful and make a complex structure? That is, one is public health amendments. After the Doha Declaration in 2001, in 2003, a decision allowed World Trade Organization members to export generic versions of patented medicines to countries without manufacturing capacity. So this was formally incorporated in the TRIPS agreement in 2005 through an amendment. And the second development is TRIPS waiver proposal. So we all see that in response to the COVID-19 pandemic, several countries, which was led by the India and South Africa, proposed a temporary waiver of certain TRIPS provisions to allow wider production and distribution of vaccines, diagnostics, and treatments. So, this proposal has sparked intense debate, with some countries supporting the waiver of the public health the reasons, while others argue that it could discourage the innovation and undermine intellectual property rights. This TRIPS agreement, the significance of this TRIPS agreement is nothing but global harmonization, economic impact, and balancing intellectual property with public interest. So that is the significance of this TRIPS agreement. So the TRIPS agreement is a key instrument in global trade that establishes a rule for the protection and enforcement of intellectual property. While it has helped harmonize global intellectual property standards and foster innovation, it also faces significant criticism, particularly regarding to the medicines, public health concerns. It impacts on developing countries. So this is basically the brief over TRIPS agreement. So what are the enforcement mechanisms under the TRIPS agreement available? So the TRIPS agreement, it forms an overall agreement establishing the World Trade Organization. It requires the members of the World Trade Organization to ensure that effective enforcement procedures are available. So the TRIPS agreement also includes provisions requiring acts by custom authorities against suspected counterfeit or pirated goods. So, what are the reasons to implement the international obligations to enforce the intellectual property rights? Number one, intellectual property right holders were not able to effectively enforce their patents, trademarks, copyrights, and other intellectual property rights in various countries around the world. They were facing inadequate procedures for obtaining, preserving, and presenting evidences. They were facing inordinate delays in bringing a case to a trial and obtaining a final judgment. They are unable to obtain with difficulty preliminary injunctions, seizure orders, or immediate relief, legal reliefs. So the damage awards and the criminal sanctions were also not adequate. So the proper enforcement mechanism was not available at borders to prevent the importation of infringing goods. So these are the reasons to the enforcement of IPR in the international obligations. So the enforcement provisions of this TRIPS agreement, it contains the details, the procedure, and the remedies that the member countries must make available in its domestic laws to enable right holders to enforce intellectual property rights covered by the TRIPS agreement. So, what are the remedies available in the case of infringement in the international arena? So, yesterday also we are talking about the remedies, civil, administrative, and criminal procedures are there. So, what are the civil and administrative procedure and remedies? So, in the case of civil and administrative procedures, the member states shall make available to right holders civil jurisdiction procedures for the enforcement of intellectual property rights. There should be fair and equitable procedures for all parties. What should be the fair and equitable procedure? Fair and equitable procedure involves defendants should be given timely and detailed written notice of the basis of the claim. And second one, the parties shall be allowed to be represented by independent legal counsel. And third, procedures shall not impose overly burden requirements for mandatory personal appearances. And all parties should be allowed to substantiate their claims and present all relevant evidences. So there should be way to identify and protect confidential information unless contrary to constitutional requirements. So the judicial authorities shall have the authority to order parties to produce relevant evidence. They have authority to make preliminary and final determinations against a party who, without good reason, refuses to produce evidence. At the same time, the judicial authority have authority to order a party to desist from an infringement. It means they can issue temporary restraining orders and injunction orders. So, what are the pre-trial injunctions? If anyone remember that pre-trial injunctions, that is Anton Pillar order and Mareva injunction. So the Anton Pillar order is also known as fetch order. Mareva injunction is known as freezing order. So this can be issued by the judicial authorities. Where the infringer knew or had a reasonable grounds to know that he or she was engaged in infringing activity, the judicial authorities shall have the authority to order the infringer to pay adequate damages to the compensate to the injury person. At the same time, it can also include attorney's fee also. So the members may provide that the judicial authorities shall have the authority to order the infringer to inform the right holder of the identity of third persons involved in the production and distribution of the infringing goods and services, how they are getting, to whom they are selling. This type of information should also asked by the judicial authorities. They have authority to ask. The judicial authorities, the judicial authorities may order a preliminary injunction and ex parte seizure, where delay damages a demonstrable risk of evidence destroyed. So preliminary injunctions, you all know, before the initiation of anything, if you go to the court will give the preliminary injunction. Injunction means to maintain the status quo. What is the current status? You have to maintain like that injunction. So ex parte seizure means without asking the other party's decision, the court orders to seize. So this is known as ex parte seizure. So this ex parte seizure may order by the judicial authorities if there is a very too much demonstrable risk of evidence destroy happens. The members shall also from this, the members were exempted, both public authorities and officials, from liability to appropriate remedial measures where these actions are taken in good faith in the administration of that law. Next, criminal procedure. The criminal procedures and penalties will be applied at least in cases of willful trademark counterfeiting or copyright piracy on a commercial sale. So, in every case, the civil and administrative procedure is applicable. But if the criminal procedure is applied, willful infringement, and the infringement is in commercial scale. So the remedies available under this criminal procedure includes imprisonment and monetary or only monetary fine. It would sufficient to provide a deterrent. So it should be consistent with the level of penalties applied for crimes of a corresponding gravity. What is the role of customs and police in enforcement of IPR? Basically, lot of these infringed goods are traveled from one place to another, from one jurisdiction to the other jurisdiction. So during that time, the administrative mechanism, if fails, it will easily uh, counterfeited and pirated the goods. But if the administrative framework is in strong, then some extent you can stop this infringement of the intellectual property right through counterfeiting and piracy. So this advancement of technology and global trade that led to the increase of intellectual property crime. So this pirating and counterfeiting have been increased, and it results the heavy monetary and security loss to the government. So some special requirements related to the border measures are there. What are these special requirements? TRIPS agreement defined the term counterfeit trade goods and pirated copyright goods. So according to the TRIPS agreement, what is the definition of the counterfeit trade goods? So the counterfeit trademark goods means any good, including packaging, bearing with authorization a trademark which is identical to the trademark validly registered in respect of such goods. So that comes under the counterfeiting trademark. And the pirated copyright means any goods which are copied, made without the consent of the right holder or person duly authorized by the right holder in the country of production. So this comes under pirated copyright. So these counterfeit pirated copyright goods give broad definition under the TRIPS agreement. So the border measures under the TRIPS involve suspension of release. So a provision which allows a right holder to lodge an application of suspected counterfeit goods. For example, the goods are catched by the custom officers in the time there is no right holder. It was traveled by someone else on the front of the right holder. During that time, the custom officer seized that goods. Now, the release of suspected counterfeit. Next, the second one is application. Describes the conditions for making an application is the prima facie evidence of infringement, and a sufficiently detailed description of goods must be there. And the third one involves security or equivalent assurance. So the security to prevent the abuse of the system by person making the allegation of infringement. And the notice of suspension, prompt notice by customs to the right holders of the suspension, so that The customary officers give a prompt notice to the right holders. So duration of the suspension. So maximum 10 working days after the application has been served, notice of the suspension. Once the time period for the right holder to commence the legal proceedings. After the 10 days, the application was drawn. After the right holder drawn the application, if the 10 days completes, even though the custom authorities are not releasing the goods, then the right holder can start legal proceedings after the 10th day. So the indemnification of the importer and of the owner of the goods. So in the case of importer and the owner of the goods, the applicant is liable to pay compensation to the importer, the consignee, and the owner compensation in case of the wrongful detention of goods, because he was sold the goods to other. So in that case, he has to tell all his rights to transfer them. If he is not to transfer all the rights, obviously the custom officer still sees. In that case, the right owner has to pay the compensation to the owner or the importer. The inspection and information. The right holder is given sufficient information and the right to inspect detained goods in order to substantiate the claims. They also takes ex officio action. The ex officio option action. It is an optional provision which allows customs to act upon their own initiatives without an clearance of goods. Remedies also there. The remedies, it talks about order destruction of infringing goods. Re-exportation is not allowed. So under the TRIPS agreement, it has the option of destruction of the infringing goods, but you don't have remedy to re-exportation because the re-exportation was not allowed. And the last one is de minimis imports. De minimis imports means de minimis is a Latin word that means a trivial, means a small. That means a small non-commercial consignments may be excluded. Small, trivial, it can be called as very less commercial valued consignments. They may be excluded. So what is the role of customs in this enforcement of intellectual properties? So the World Customs Organization was established in 1952 with regarding to the customary officers. World Customs Organization was established. It is an independent intergovernmental body with responsibility for dealing with customs issues. It aims at enhancing the effectiveness and efficiency of customs administrations and assist them to contribute to national development goals, particularly in the area of trade facilitation, revenue collection, community protection, and supply chain security. The customs role in enforcement of intellectual property rights. has been highlighted by the World Customs Organization. What they highlighted? First one, they has to facilitate international trade at the same time by protecting the border. The second one, the planning at the international level against transnational organized crime, and they can assist the enforcement of TRIPS agreement. The World Customs Organization intellectual property rights model legislation has been developed to help countries in drafting or revising their existing custom legislations. So, in the year 2013, 2003, the World Custom Organization Enforcement Committee adopted the new model law on broader measures, but it is not binding upon the members. It goes beyond the minimum standards required in the agreement on the TRIPS. So it represents the best practice in the area of IPR legislation for customs and will be a useful aid to those administrations drafting or reviewing legislation. So, what is the role of Indian customs in the implementation of IPR, global IPR? So, the Customs Act 1962, later amended by the Finance Bill 2005, it contains the measures for combating illegal import and export of goods, including protection of patents, trademarks, and copyright. So the Trademark Act 1999 prevents the owner of trademark claiming infringement in respect of a product which he or she has produced and to which he has attached a trademark or where he has expressly or impliedly consented to the use of the trademark. So the Foreign Trade Development and Regulation Act 1992 is that if imported goods do not conform with the standards of weights and measures, Packaged Commodities Rules 1977. So the act is Standards of Weights and Measures Packaged Commodities Rules 1977. If any wood which was imported was if not conformed with the standards, then they are prohibited goods. Such goods can be stopped by the custom authorities from being imported. So, what is the role of police in implementing this enforcement of intellectual property rights, international agreements? So, with regarding to police, the Interpol, which was the world's preeminent police organization, which endeavors to prevent, detect, and suppress crime. So, this Interpol, it creates a multi-agency working group known as Intellectual Property Crime Action Group. This Interpol Intellectual Property Crime Action Group has a representatives from the police, customs, intergovernmental organizations, and private sector associations. This group works as a forum for coordinating and enhancing international action against intellectual property crime. This Interpol recommends the good practice and successful models for investigating intellectual property crime nationally should be established. So what is the role of implementing this intellectual property rights enforcement? So the Trademark Act 1999, it authorizes the police officer who is not the below the rank of the deputy superintendent of police, on being satisfied, he can search and seize infringing goods. So according to the Trademark Act, not below the rank of deputy superintendent of police, he is satisfied, he can seize and search the infringing goods. But for that, the police officer, before making any search and seizure, he has to obtain the opinion of the registrar on the fact involving that the offense relating to trademark and shall abide by the opinion so obtained. According to the Copyright Act 1957, any police officer not below the rank of sub-inspector may, if he is satisfied that an offense under this act in respect of the infringement of copyright in any work has been, is being, or is likely to be committed, he can seize without warrant all the copies of the work. So what is the dispute settlement mechanism under this intellectual property, international organizations of the intellectual property rights? So basically, this settlement of disputes, which was adopted by this intergovernmental organization, international governmental organizations, were the most of the ADR mechanism. We are already discussed the ADR mechanism briefly. Along with that, here is also same the procedure with regarding to arbitration and mediation. But here there is a one small concept was introduced due to the technology advancement. So the internet domains and name dispute resolution. So internet domain names were subjected to infringement. So the WIPO conducted a internet domain dispute resolution was possible. So this popularly internet domain names have increasingly come with trademarks and other intellectual property rights. Especially in December 1999, the WIPO Arbitration and Mediation Center became the first provider of dispute resolution services, the Uniform Domain Dispute Resolution Policy. So this Uniform Domain Name Dispute Resolution Policy applies to registrations in generic top-level domains, that is .com, .net, and .org, etc. This Uniform Domain Name Dispute Resolution Policy is limited to cases of registration and use in bad faith. For a complaint to succeed, the complainant must establish three cumulative criteria. The first one is the domain name is identical or confusingly similar to a trademark or service mark in which has rights. Second one, the registrant, the domain name, has no right or legitimate interest in respect of the domain name. And the third one, the domain name has been registered and is being used in bad faith. So if these three work happens, then only the complaint must be raised with regarding to the Uniform Domain Name Dispute Resolution Policy. So for this, the settlement of disputes was gone through by ADR methods only. So today's, according to this syllabus, we are discussing today the importance of World Trade Organization and the structure of World Trade Organization, establishment of World Trade Organization, along with the TRIPS agreement and the enforcement of TRIPS agreement, and the role of customs and police in IP enforcement. So in the case of customs, World Customs Organization was established. So with respect to police, Interpol is there, and the settlement of dispute through the mediation, arbitration is ongoing. So for this, we have completed the today's lecture. So tomorrow we can start with patent in newer areas. So if you have any doubt, you can ask. Otherwise, you can put in comment box also. No problem.
I think there is no issues. They are clear.
Yes, sir. Yes, sir.
Hello. Yeah, thank you, sir. Then
Someone.
we'll meet again tomorrow,
Sir, 1
same
minute.
time at 4 o'clock. Thank you.
Okay, sir.
Yeah.
Okay.